Well, good evening and welcome to the program. This is the Limelight and my name is Prince Apollo. Now, this evening we reflect on the right to bail as stipulated in the Constitution of Uganda, Article 28(3), but specifically the mandatory bail relating to prolonged detention. And it comes at a time when we see incidents of suspects who have been in detention for quite a long time, actually a period exceeding the stipulated 180 days for mandatory bail. And to discuss this matter, I've been joined by Counsel Anthony Asimwe, and Asimwe is the Vice President, Uganda Law Society. Welcome to the program.
Thank you. I'm happy to be here.
So let's go straight. What can you describe as the bail status currently relating to these cases where we see suspects overstaying on remand?
Right. Thank you very much. I think I need to begin from the position of the rights of individuals, and the most important of them being the right to personal liberty. And Article 23 of the Constitution guarantees every Ugandan a right to personal liberty, and the exceptions for someone's right to personal liberty being taken away are very specific in the Constitution. And the outright clear guideline is that there should be no there has to be a specific justification where someone maybe has been tried and convicted and by a competent court of jurisdiction. And now it comes back to aspects of pre-trial detention. Pre-trial detention, basically, when someone is in detention before the trial, is a scenario where someone's liberty is being denied. Now, Article 28 of the Constitution provides what we call a fair hearing, a right to a fair hearing. And these rights I'm talking about are rights, they say, are non-derogable rights. Now, a right to a fair hearing includes also a speedy trial. That is why the Constitution also has safeguards. Someone can be arrested and detained pre-trial, pending the trial of their case. But again, that Constitution, that same article says there is a presumption of innocence, that every person who is suspected of an offense is presumed innocent until that very person either pleads guilty or until the state brings evidence to prove that this person is guilty, then he's sentenced. And if his sentence is detention, he's detained for that period of time. Now, that is why the Constitution brings in that safeguard under Article 23, where they say any person who is facing a trial because of that presumption of innocence is entitled to apply for bail pending the hearing of their case. And this is because in most cases there is long periods. Sometimes they still the state is still preparing. There are so many witnesses. The investigations are still ongoing, and the person who is in detention is literally serving sentence even before they are tried or before they are convicted. Unfortunately, you find some people being acquitted of these charges, but someone has spent a lot of time, in detention. So that is really the basis of that, that aspect of bail under the Constitution, saying it is for purposes of protecting that right to personal liberty and the presumption of innocence, which stems from a right to a fair hearing under Article 28. Now, when you talk about the status of bail in the country, of course, like you're saying, it's a constitutional provision. We have several laws and procedures where the law is very clear that whereas the Constitution guarantees someone a right to apply for bail, it is not automatic that you're going to be granted bail. The judges or the judicial officer hearing the matter is given a discretion to determine whether to grant or not to grant bail. And the law is also very clear, the circumstances under which court can grant bail or under which court can deny bail are also very well stipulated. You talked about people overstaying. You mentioned the 180 days. The Constitution, again, also Article 23, I think sub-Article 6 is very clear on those lengthy pre-trial periods. If it is a minor offense, an offense triable by the magistrate's court, if someone has been in detention for 60 days and above without their case being heard, they're entitled to what we call mandatory bail. And if it is a capital offense, these are cases triable by High Court. If someone has been there for more than 180 days, then this person is also entitled to what we call mandatory bail. When you talk of mandatory bail, it means the duty of the court. In fact, the words are coached. There is the word shall. The court shall grant this person bail on its own cognizance, meaning if court is notified that this person has been in custody, 180 days have passed, they've not been the case, they have not been tried, the case has not yet been brought up for trial, then the court can on its own, should on its own grant this person bail and set conditions. These conditions really are to ensure that the person appears or comes back to court whenever called upon. It doesn't mean that when they grant you bail, your case has ended. Now, unfortunately, we are seeing scenarios where these provisions of the Constitution have been overlooked by judicial officers. Because you see, the judicial officer has a lot of discretion. And what the courts have said, what the law has said, even the Constitutional Court in so many other decisions, is that while exercising this jurisdiction, the courts of the judicial officers should do it judiciously. You follow the law. Now, these are long periods, the pre-trial, where I find people in custody without being brought to court, or they are being brought to court but their cases are not taking off. The Constitution makes it clear that for such a person and that period of time, the court does not have, there's no actually option, there's no the court does not make it optional. But we've seen scenarios where judicial officers have overlooked this and they are creating their own law. The Constitution is the supreme law. No other law that should be brought up, or that you should consider, whether it's a policy, whether it's a guideline, that should supersede the Constitution. Now, I think in the recent past, in 2002, the Chief Justice brought up what we call the bail guidelines. And one of the purposes of the bail guidelines was to create uniformity. And when you read some of it, they're saying to avoid lengthy pre-trial detention. Unfortunately, it has even made it worse. What would do some of us who practice criminal law? Someone who is who has been arrested and detained, and it's a capital offense, they've spent more than 180 days before they are committed to High Court, because there's a process which you call committal. So once you've been committed to High Court, the Chief Magistrate or the Magistrate Court no longer has power to deal with you. But the constitutional provision is so important that even if it's a capital offense and this person has been kept in custody for more than 180 days and the state has failed to commit the person to High Court, this magistrate, the Chief Magistrate, the Magistrate Grade 1, has power to actually grant this person bail. But in this way of trying to to bring reforms and the bail guidelines, we are seeing directives from the judiciary saying now if someone has clocked the mandatory period, the magistrates, the chief magistrates, do not have power to grant this person bail. Someone has to first file an application to the High Court, and this is why we are seeing challenges. People are filing these applications. The moment you file an application like today, the following day, that's when the state will remember to bring committal papers. Or more still, people have filed applications in High Court, which applications have not been heard.
That's what I wanted to ask you. That in case this person files an application for mandatory bail, but it is not granted, then what is that? Because you said they overlook. Can it be a violation of the Constitution? What do you think?
Now, definitely, if I'm filing an application under, Article 23(6), where the person has overstayed, the only thing one has to prove is that this person has been in custody for more than 180 days. He has not been committed to the High Court. His case has not been heard. He's in pre-trial detention, and the court should grant the person bail. Now, under that application, if I was to urge that application, I don't need to bring so many things. Because the only thing you need to prove, which is constitutional,
the suspect has been
for more than
180 days.
Now, we are seeing scenarios where judges, judicial officers are coming up with other considerations under that law, which is very wrong. That is an abuse, a total abuse of the Constitution, and they should stop it. It is so wrong. But again, the other unfortunate thing is some of these applications have been filed, but they're not even fixed. Someone files an application, you spend another 6 months to have this application fixed for hearing. Whereas before, if a person is brought before a chief magistrate for mention of the case and you notify the court, in fact, even when court gets to know this information, you don't even need to apply. The court should automatically grant. So we are seeing an abuse of the constitutional right.
So it is an abuse of the constitution.
Exactly.
Right,
and unfortunately, by an institution which should be protecting individual rights, which is the judiciary.
Under these circumstances, what would be the remedies? Or what can the suspects do, or their lawyers do, to perhaps secure their freedom, their right?
Well, we've been saying this. We have a very big challenge with our judiciary, where judicial officers fail to apply the law the way it is, disrespect the constitution in broad daylight. And we are saying that we need to have reforms. We need also to have, a competent judicial service commission where judicial officers who, abuse the law should account. We have an unfortunate incident where the judicial officer is almost above the law. And even when you go to the Judicial Service Commission to complain that this judicial officer has failed to do what they're supposed to do, they're actually not punished. They are not they are not held accountable. So we feel one of the areas where I need to have reform is to hold these individuals accountable. Let them explain why are they breaking the constitution, because you cannot say you're creating another justification for denying a person bail when the constitution says this is mandatory bail and the judicial officer seated. So one, it is reforms, and also in the law itself, and also creating, ensuring that we have a strong judicial service commission where, by the way, the public should participate. The public should be given an opportunity to know these judicial officers who are appointed, how they are appointed, and where. And again, I need to mention this. We have also a big challenge of lack of independence for the judicial officers. The judiciary, the law says we should have an independent judiciary. But there are scenarios where judicial officers do not act independently, especially when you look at political cases. They are under pressure to impress the appointing authority. And other people will say they are orders from above. If they say do not grant this person bail, they will not grant. Yet under normal circumstances, and even in our constitution, we have separation of powers. And without a competent and independent judiciary, we are wasting time. We shall continue seeing this total disrespect of the law in our country, especially the constitution.
Okay, talking about the powers from above, we have had higher authorities speaking about actually proposing scrapping of bail. So can we perhaps say that this is, in one way or another, a move to scrap bail?
Well, like I said, this kind of political influence and, that is pressed on the judiciary is very unfortunate, because the 1995 Constitution is made for the people and no one is above the law, regardless of the position of the person, not even the head of state. We must respect the Constitution the way it is. There are procedures for, amendment to the Constitution, and the way, if you look at the constitutional, the commissions, the Odoki Report Commission, the process that they went through to come up with this Constitution and the provisions, it was for the people, suggested by the people. That is why you see sometimes some of these political heads at the end of the day come back and they become victims of some of the orders they are making. So it is a very dangerous move. We should not stay there. And again, some of this influence, like I'm saying, some of it is actual, and another is also perceived. Because some people will say, the other day I had the president say we shouldn't grant bail to thieves, should also not grant bail, which is wrong. A judicial officer should stand their ground. They took an oath, and whatever they do should be for the people and by the people. They are working for the people. They're in those offices for the people, not for individual human beings.
Okay, Council, as we prepare to conclude, you propose that there should be a review. But who should initiate this review? Where does it start? Where does it, originate? The process for review, where does it originate?
Well, we have leaders we send to Parliament. Parliament is the legislative body. Unfortunately, we're having a scenario where even the leaders, the people we send to Parliament to legislate, are not even bothered about the most important aspects. Of course, on our part as the Uganda society, we are doing our part. We are trying to push for these reforms, because one of our mandates is to advise government on matters touching the law and anything to do with legislation, including Parliament, court, and we keep giving our opinions.
Have you done
it is? We have done this
specific issue.
We've done this several times. We've even gone to court. We've litigated before on issues of bail. I think the Uganda State has filed several matters as far as 2005 on the aspect of right to bail. And we have clear judicial decisions. That is what we can do. We have court decisions that are very clear, including Chiza Besigye in 2006. The Constitutional Court pronounced itself on the right to bail and what the consideration should be. But now, as we are here seeing judicial officers who are departing, you know, in law we have what we call the doctrine of precedent.
Yeah.
If the Constitutional Court has set a precedent, or the Supreme Court, the lower court should not come and depart from it. That's why we are saying the most important thing is to have an accountability system or process for these judicial officers, because they yield a lot of power to respect the law. But if they are using the law as a tool to fight specific individuals, either on their own or on behalf of others, then those people should not be in those offices.
So you're saying the remedy is in our members of parliament to kickstart a process to do a review,
a reform.
The
law. Yes,
reform
I know
of the law.
The law make it very clear, and also and these reforms they're talking about. But they will have a very good constitution, have very good laws that are written down. But it should be, you know, a human rights based approach, where if a judicial officer, for example, has misapplied the law or has completely run away from the provisions of the land and office, what should happen to them? Should that person continue working? Should they be apprehended or should they not be apprehended? We should have a policy on that. We should have a law on that, so that they know, much as they hold these offices, there's an accountability process.
Okay, is it only this aspect of, or this aspect of bail, or there are other reforms perhaps that are attached to this particular issue?
Well, there are quite a number of them. It's not the only one. There are so many
related.
Yeah, there are so many
related to this issue,
related aspects, including the law, and also coming up with other, you know, maybe very particular provisions. I talked about the guidelines.
Okay.
I don't see why we even have those bare guidelines if they cannot achieve what they're supposed to achieve. Those are some of the things we should not have, because if the guidelines are enabling the judicial officers, are enabling, you know, courts to abuse the provisions of the Constitution, then those are the laws we should not have on our law books.
So the answer is in Parliament, not elsewhere.
Answer is in Parliament, the answer is in the people of Uganda, because I mean, you also need to stand up and fight for our rights. You cannot sit back and you see your rights being abused and wait for other people to fight for it. So that is in aspects of, if you are looking at law reform or coming up with other laws and policies or legislating. But then again, it is also upon us as the people of Uganda. And I need to make this clear on court to the judicial officers, the judiciary. It is the judiciary that has the power to ensure that cases that are before them, people come to their courts to get justice. Let's deliver justice. Let's do what we take the oath to do, not to impress other people.
Okay, as we conclude also, in the short term, before Parliament kickstarts this process of reviewing and reforming the system, what can now the suspects do, perhaps in the short run?
Well, like we said, it is a right of these people to apply for bail, and what we've been telling the suspects, whether they are represented legally or not, they should continue applying for bail, because there is no limit to the number of times you can apply for bail. If it is denied today, you can still apply tomorrow. You can still apply another day. Maybe you'll be lucky, and your application is, you know, handed to a judge who understands the law, a judge who understands their call of duty, and do that. So we shouldn't give up. You shouldn't go back and fold your hands and say, because I applied for bail the other day, they refused to grant me, let me sit here and wait. You can make another application. But then again, we've also been telling these people, if you feel, or if you've realized that the judicial officer handling your bail application has completely abused the law, these are some of the circumstances under which you can even bring a complaint to the Judicial Service Commission, because there's a Judicial Service Commission that should handle complaints brought against judicial officers who abuse the law or who abuse their offices. That is actually abuse of office. So again, there's also that knowledge gap. So we call upon people, the Ugandans, both the victims or the suspects, like you're talking about, the lawyers, the members of the bar, and other members of the public, it will be a relative, not to give up, but to continue fighting for this, because these are rights that are given to us inherently as a human being. It's not the state or anyone that gives you that right. You're entitled to all that.
Finally, looking at these cases where mandatory bail has been denied, do you see a particular trend, perhaps with the cases related to politics, with cases related to other aspects of crime? What trend do you see?
Of course, if you notice, you realize most of these are political cases, and it's absurd that the political figures are using the members of the judiciary, are influencing them to, you know, to abuse human rights or rights of other individuals. It is a very bad trend, and it should stop with immediate effect, because at the end of the day, you never know who's going to find themselves at the end of the other coin. I mean, some of us practice law. We've applied for these mandatory bail and people have been granted. But the moment there's influence peddling, there's someone who has an interest in a case, they will tell you this is a high profile case. You find challenges of that nature.
Your final word on the show, Anthony.
My final word is, well, I appreciate you for coming up with these kind of topics, because the public out there needs to know, what does the law provide for? What should I do? But again, I call upon the responsible people that we need to respect the Constitution as is, because if we fail to protect the Constitution, it will not protect us when we need it. Yeah.
Thank you so much, Anthony, and thank you so much for your time.
You're welcome.
And your insights. And that's it from Anthony Asimwe, the Vice President for Uganda Law Society. And he says now the onus is on Parliament to perhaps kickstart a process of reviewing and reforming the law to provide for this constitutional right to bail. My name is Prince Apollo. Let's catch up again next Friday in another episode of The Limelight. Good evening. God bless you. God bless Uganda.
Download the Salt Media app from the Google Play Store and the Apple App Store.